I think there's a lot to unpack in that question, but the first thing we must do is, of course, acknowledge and express our deep condolences and sympathies to the Malaysians who lost their lives on the, I think it's the 9th of February 2013. 10 policemen, from what I understand, members of the Police Diraja Malaysia, lost their lives in that incursion. And what we must also understand is that the incursion included some 260 foreigners from the southern Philippines whose objective was to take back the territory of the east coast of Sabah. And they did so purportedly as a territorial army of the now defunct Sultanate of Sulu. Now, your question asks whether that alone is sufficient to rescind the deed of cession. I would argue this. Yes, it would be, but that presumes the deed of cession was an ongoing obligation at the time. The better argument is to say that, at least in my view, from the view of Sabahans, the day we became Malaysia, that was the end of the question as regards to whether there is any continuing obligation with the Philippines or with a foreign sovereign. Let me elaborate a little bit. The deed of cession is 1878. Now, it's problematic in the first place whether that deed of cession itself is an international document, a document with any kind of international effect. Secondly, the document itself is unclear as to which parts of Sabah it pertains to. If anything, it only pertains to parts of Sabah because Brunei was also a sultanate with which Dent and Overbeck being the original signatories of the 1878 agreement. Dent and Overbeck also signed a similar agreement with the Sultan of Brunei. And it can be credibly argued that the claim to Sabah now by these purported Sulu heirs under the latest arbitration can only be a claim for part of Sabah. Now, when would be the better argument as to when the deed of cession was effectively extinguished? In my view, the commencement of what you can call the diminution or the extinguishment of the 1878 deed was in 1881 when the British government granted charter status to Dent and Overbeck, and later on that became the North Borneo Chartered Company. Later on in 1888, there was a protectorate arrangement made between the British government and the North Borneo Chartered Company, and in that protectorate agreement, it says very clearly that North Borneo is recognized as an independent state, but that the North Borneo Chartered Company will administer that independent state in accordance with the charter. So you have a very interesting situation where you have two things operating. First, you have continuous occupation and continuous administration by a British subject, the British subject being the North Borneo Chartered Company, which in itself is a child of the British government executive. Secondly, the British Parliament was free at any time to alter the terms of the charter. But where it becomes interesting is that whilst administration is British, the British government at the same time recognized independence in terms of North Borneo itself. So recognition, as you can recall, of a territory being independent and sovereign is in and of itself sufficient to grant personality, international personality to the territory of North Borneo. So if there was a cut-off point to the deed of cession, it might have been in 1888. But in any case, right until the end of the protectorate arrangement, which is 1946, it's almost 90 years, the effective occupation and administration was British. And it's very hard to make the argument that there was any other sovereign power exercising such control over Sabah at that time. And of course, later on towards 1963, we have the declaration through the Cobalt Commission that Sabahans wanted to be part of Malaysia, which I think you'll get into later. So in short, the answer is yes, it would have been enough to cancel the deed of cession, but I think the deed of cession died a long time before the 2013 incursion. One more point. I know I sometimes forget, but let's not think that the annual payments were anything but ex gratia payments. The Malaysian government by grace, chose to acknowledge a historical connection with the Sulu Sultanate. But ex gratia, by its very definition, means without any legal consequence. It's like, paying tribute to somebody or acknowledging somebody's role. It's not saying that you owe them something, but you are acknowledging their role without any legal consequences or admission that there is legal liability. And as a Sabahan, we were very shocked to learn that ex gratia payments were going on in the first place. We never thought that they kept on being paid by the Malaysian government. So when they finally ceased in 2013, that came as a shock to a lot of Sabahans, not because we stopped, but because we were paying those payments in the first place. All right, thank you. Like any legal question, the answer is, well, it depends. Now, it's easy to say that the successor of the North Borneo High Court is clearly the High Court in Sabah and Sarawak. And it's very, very tempting to say that because a dispute concerning or related to the 1878 Deed of Cession, because a dispute relating to it was submitted for determination in the North Borneo Court, that jurisdiction has been ceded altogether. Now, I make my point in saying that it's tempting because we have to look at the nature of this dispute. The dispute before the North Borneo Court wasn't concerned with whether there was an obligation to pay. The dispute was concerned with to whom is the annual payment to be made. And this was following the death of the then Sultan of Sulu, and there was a dispute that broke out in the Philippines as to who were his heirs and successors and to whom was this annual payment due. And we call it the Nurul case or Nurul case. Now, what's important to observe about that case is who were the defendants. The defendants were the North Borneo Chartered Company and the government of North Borneo. The better way to use the McCluskey case is this. The parties to the deed of cession were the North Borneo Chartered Company and ostensibly, by extension, the then government of North Borneo. It doesn't, however, follow that the Malaysian government or indeed the UK government are the successors of the North Borneo Chartered Company or the government of North Borneo. And the reason for that is that these are British subjects operating in an individual capacity, but they happen to be administering a territory that the British had already recognized as independent. So there's a separation here. You have an administrative authority that's British, but a territory that is independent. And it's only through domestic constitutional mechanisms in our federal constitution that the High Court in Sabah and Sarawak becomes the heir of the North Borneo Court. That's a domestic legal instrument. In terms of international personality and privity of contract in these kinds of cross-border arrangements, it is difficult to see how what's essentially a private contract that went to dispute in the North Borneo Court, it's hard to see how that private contract can then go on to bind the Federation of Malaysia. Now, that's one point. The second point is, it's very curious. The dispute resolution mechanism in the deed of cession itself is not access to the courts or redress to the courts of North Borneo. It's actually to bring any dispute to Her Majesty's Britannic Council in Brunei. So it is quite curious why this dispute wasn't referred to the courts in Brunei, if anything. And it leads to the question, was it even proper for the North Borneo courts to take jurisdiction? What is clear, though, is that in 1939, the Sulu heirs did not follow the dispute resolution mechanism in their own deed of cession. And of course, in recent times, the so-called new heirs to the Sultanate are also not following the dispute mechanism in the deed of cession. The issue of self-determination came up after the Second World War, And it was part of a broad United Nations policy move to give the right of self-determination to a number of former colonies, of which North Borneo was regarded as one. Now, there were essentially two choices that were presented to North Borneo at the time. The first was to become independent, and the second was to become independent through the formation of the Federation of Malaysia. And to determine the will of the people of North Borneo, a United Nations commission was set up called the Cobalt Commission, and they conducted referenda throughout the state of Sabah, from the east coast to the west coast, from the interior to the north, from the north down to the border of Kalimantan. It was a very comprehensive survey and referenda, and the results were split, 2/3, 1/3. 2/3 wanted Malaysia, and 1/3 did not. Of the 2/3 that wanted Malaysia, 1/3, half of them, wanted Malaysia on certain terms, and those terms later on became, to some extent, incorporated in what we now know as the Malaysia Agreement 1963. And the other 1/3 wanted Malaysia on any terms and conditions. Now, why did Sabah choose to go to Malaysia? Well, historically, unlike Brunei, there was no subsisting protectorate treaty with the United Kingdom or any other world power at the time. Had Sabah gone independent, clearly it would have fallen through force or other means into one of two of its larger neighbors, be it the Philippines or be it Indonesia. So the will of the people of Sabah can be expressed as saying at the time that they did not want to be Indonesian, and nor did they want to be part of the Philippines. And they knew the risks of choosing full independence without Malaysia. And clearly, what we take away from the will of the people of Sabah, and indeed the sentiment of Sabahans even today, is that Malaysia is not perfect, but we'd rather be Malaysian than Filipino, and we would rather be Malaysian than Indonesian. And I think no matter how much we whinge and say other things, it's like any family. Brothers and sisters sometimes fight, but you're still family. Now, you asked what is the effect of this self-determination, say, on the Sulu claim? Well, the effect is that this Sulu arbitration is not about the Philippines taking over Sabah as a territory, but what it is the Philippines using Sabah and weaponizing a claim against the Federation of Malaysia, using Sabah as the reason, and bringing forward an agreement that has long since ceased to be relevant, and weaponizing that in a way to cynically extort funds from the Federation of Malaysia to the detriment of its people. Now, how does that make Sabahans feel? It makes Sabahans feel terrible, but more angry. Not so much because it's our fault. It's not the fault of Sabahans. More so frustrated that this issue of the territorial claim to Sabah has not been resolved much earlier. And I mean, we can look at various treaties and arrangements and declarations. I mean, you'll recall I was talking earlier about the charter status being bestowed on the North Borneo Chartered Company. That's 1881. A little bit later on, 20 years later, after protectorate status had been established, in 1903, the Chartered Company wanted to know whether the islands, certain islands off the coast of Sabah, were also included in the deed of cession, so that the Chartered Company could also administer that. So that led to a confirmation agreement, 1903. Now, the Philippine government says the confirmation agreement is an admission that the deed of cession is only a lease. But it doesn't mean that at all. The confirmation agreement 1903 just says that along with the deed of cession and the territories described within are to be included these islands. So the same restrictive format that binds the deed of cession to an agreement that has no international effect is the same restriction that binds the 1903 confirmation agreement. And it really is, again, in terms of the Philippine point of view, it's very confusing why they keep on talking about whether or not this is a lease or whether or not it's a cessation or whether or not territory is being ceded. The truth of the matter is that is a red herring. It doesn't matter what the deed of cession says, because in the end, the deed of cession was extinguished through the act of statehood and sovereignty on the part of the United Kingdom for the 90-odd years that the territory of North Borneo was under effective occupation and administrative control by the UK. So all of these agreements, all of these claims by Philippines based on what the law was back in 1800, what the law was back in 1900, what the law was back in 1946, and indeed what the law was back in 1963, these are all a little bit too late. I'm going to expand the question a little bit. After the Cobalt Commission, of course, we formed Malaysia. But before we formed Malaysia, the Philippines protested. So we got the Manila Accords just before the formation of Malaysia. And if I'm not mistaken, paragraph 12 of the Accords said that the formation of Malaysia is without prejudice to the Philippine government claim to Sabah or any territory within Sabah. Now, it's interesting to note that they use the term or any territory within Sabah because even in 1878, it's not clear whether the Sultan of Sulu had control over the whole of Sabah. At best, he had control over parts of Sabah, mainly the east coast, and Brunei had the west coast. But largely, the exertion of territorial sovereignty was very limited since the deed of cession was made. And I think the British position of recognizing that the territory is under no sovereign control effectively is the better position to take. And consequently, it then makes sense. It then makes sense for the people of Sabah being independent to then have the right to exercise that independence and choose whether to form a Malaysia or to declare itself as an independent state altogether and free of North Borneo chartered control. So I think that would be the stronger view to take. There's definitely elements of abuse of process in the arbitration claim by the so-called heirs to the Sultanate of Sulu. The first abuse is that you've taken arbitral proceedings in respect of a document that does not contain an agreement to arbitrate in the event of a dispute. So there's no arbitration clause in the 1878 deed of cession. That alone should tell you something about abuse of process being not only at the heart of all of this, but in its origin. The proper dispute resolution mechanism is in fact a referral to Her Britannic Majesty's Consul General in Brunei, or if there's none there, its successor. Now, upon checking, there is still Her Britannic Majesty's, or should I now say His Britannic Majesty's Consul General in Brunei. So the dispute ought to be referred there. Second, it's doubtful that even if you could somehow find that this agreement's arbitrable, it's doubtful that whether Malaysia or indeed any other sovereign government such as the UK is a party to the deed of cession in the first place. So the second abuse would be you are bringing to arbitration a nation state that is not party to the agreement over which arbitral determination is being sought. And the reasons for that I've outlined earlier is that the act of independence earlier, in my view, by North Borneo and the recognition of it by the United Kingdom or the British government through the 1888 Protectorate Agreement, the recognition of North Borneo independence was, in my view, sufficient to kill off the deed of cession and its ongoing effects. The third sign of abuse is the choice of jurisdiction. Why go to Spain? Why go to Spain? The Spanish have never exercised effective administration or continuous occupation of North Borneo. And in fact, I mean, I'm not going to get into the history, but the British and other powers did a very good job at making sure the Spanish had very little, if anything, to do with North Borneo. So why go to Spain? Why not arbitrate in Malaysia or the UK? Secondly, Finally, choice of moving the arbitration from Spain to Paris. Very odd. We are unable to find any instance where it is permissible, either under Spanish or French law, to unilaterally move the seat of arbitration. So why did the arbitrator do this? Well, there was a finding of the Spanish court that said that the appointment of the arbitrator was unlawful and irregular. Now, if the arbitrator had stayed in Spain, then he would not have been able to render an arbitral award. So what did he do? He moved to Paris, where there is no Parisian or there's no French court finding that his appointment is invalid, and then proceeded to render the award. I don't think there's any example of the seat of arbitration being moved unilaterally. I don't think there's any international example to date of the seat of arbitration being moved unilaterally to avoid an adverse finding of the original seat of arbitration's domestic court. And it is very odd that you would render a partial award in Spain, but the major award or the final award in Paris. I think the abuse here is that he wanted to avoid the jurisdiction of the Spanish court, knowing the jurisdiction of the Spanish court has made an adverse finding against the arbitrator. And that's why he went to Paris. And the other abuse of process is, notwithstanding the fact that the Spanish court has stayed the matter, the French courts have stayed the French award, they continue nonetheless to enforce the arbitral award in other countries. So the abuse is that in both, if you can argue or you accept the argument that the seat of arbitration is in both Paris and Spain, if you accept that, which we don't, nonetheless, the parties aren't even respecting the laws of those countries, which have effectively put a stop to the effect of the award. They've gone to other countries to try and get satisfaction. So it's not just a single abuse, it's a litany of abuses of process. And it's being well funded, which I think is the overriding policy consideration here, where we are looking at litigation funders as being the cause. And there's a broader policy discussion as to the role going forward that litigation funders ought to have, or whether they ought not to have, whether they ought to be prevented by the agreement of New York Convention countries not to be permitted to interfere in such things. That's a discussion I think that's probably outside the scope of this interview.